Question of the day. Do you own any stocks in a company? Let me rephrase it. Have you ever purchased shares in a publicly traded company such as Google, Amazon, or Louis Vuitton? As a business owner, we are all generally familiar with the term stock, but do we really know how stocks work in a privately held company? Well, if not, I want to give you the Stocks 101 crash course. So let's jump right into it.
My faith rising. I'm crawling out the trenches.
Hello visionaries, welcome back to my channel. My name is Marisa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. For the purpose of this video, I will only talk about privately held companies. And by privately held companies, I mean C or S corporations that are not traded publicly, such as Talbert Law Office, a professional law corporation that is owned 100% by me. Okay, so let's define some terms. Shares and stock. These terms are used interchangeably because they mean the same thing. In a privately held corporation, ownership is represented by shares of stock. Each share represents a fraction of the corporation's equity. For simple math, if you have 100 shares of stock in your corporation, then generally you can have 100 owners who each own one share of stock, and that represents 1% ownership in the corporation. Alternatively, you can have one owner who owns all 100 shares of stock in the company, and that owner would own 100% of the company. On the other hand, you can have two owners who each own 50 shares of stock and therefore each own 50% of the company. I think you get the point. The other term that I want to define is stockholders and shareholders. Again, these two terms are interchangeable and they mean the same thing. Now, the owners of stock or shares in the company can either be an individual or an entity. Those individuals or entities who own stock or shares in the company are called stockholders or shareholders. And these shareholders have certain rights and privileges based on the number and types of shares that they own. Now, an S corporation is only allowed to have one type of stock, but a C corporation can have several different types of stock. For the sake of simplicity, I won't discuss all types of stock that can be held. However, there are two common types of stock that I will cover. The first one is common stock. Typically, common stockholders have voting rights, which allows them to vote on very important matters regarding the business and business transactions within the company. Stockholders may also receive dividends based on the company's profitability. The second type of primary stock that I'll cover is preferred stock. Preferred stockholders are usually reserved for investors. Preferred stockholders usually do not have voting rights, but they do have a priority claim on receiving dividends. This means that if there is profit, the preferred stockholders will receive a cut of that profit before the common stockholders. So let me tie this up together for you. In the most basic corporate structure, I'll use Talbert Law Office for an example. TLO is a corporation that has both common stock and preferred stock. I, as the CEO of Talbert Law Office, own 100% of all the common stock within the company, which allows me to vote on all decisions and have 100% decision-making authority. Although Talbert Law Office does not have investors, we have preferred stock that is reserved for our employees. This allows Talbert Law Office to offer stock options as an employee benefit, and those employees do not have voting rights or decision-making authority, but they do receive a cut of the profits or they are paid dividends before I am as a common stockholder. These types of arrangements are why a shareholders agreement is so important when you own a corporation. Your shareholder agreement outlines who can own what types of shares, how those shares can be used, sold, or transferred, and just provides overall guidance as it relates to ownership within your company. Now, when you issue shares, those shares are particularly valued at a certain price. And that valuation is determined through various methods. The value of your shares may be determined by a one-on-one negotiation between the company and your investors. You've seen examples of this on the hit show Shark Tank, where one of the sharks may offer a company owner $100,000 for 25% equity in the company. Or you may value your shares of stock based on historical sales and future expected cash flow. In some cases, such as with a startup company, you may not have any historical sales or any cash flow to use for evaluation. So you could issue what is called par value stock. Par value stock is the value set by the corporation in its articles of incorporation or in its shareholders agreement. It's usually set very low, maybe for $1 or even 1 cent. And this value is not at all related to the fair market value of the shares and has no relevance on what those shares would be valued in the marketplace. Par value merely just sets the floor value of your stock so that your valuation can only rise from there. Next, I want to talk about the shareholder agreement. You've heard me mention the shareholders agreement a couple of times in this video so far. And I have a much more in-depth video about shareholders agreements that I'll link down in the description box below. But I do want to highlight the importance of a shareholders agreement, particularly when it comes to the transfer of stock and ownership of the company. People come and go from employment and businesses all the time. If someone leaves your company, even if it's a co-founder, by default, that stock is now property that leaves with them. As a stock owner, that individual or entity can choose to keep their stock, they can sell their stock, or they can transfer their stock to a third party, such as their child, such as a spouse, or some other company. Now that new person that either bought or inherited those shares is now an owner of your company, unless you have restrictions outlined in your shareholders agreement. So your shareholder may state that if someone leaves the company under unfavorable circumstances, then the company has a right to automatically buy those shares back. Your shareholders agreement may state that no shares can be sold to a third party without the company's consent. Or your shareholders agreement may state that any person who owns shares can only sell their shares to other shareholders within the company. These are decisions that directly affect you as a business owner, and it is why I'm so adamant about not skipping over your contracts or your corporate formalities. The last thing that I want to leave you with about stocks is that stocks are regulated by securities laws. Securities laws are intended to protect the investor when it comes to the issuance and sale of shares. This is nothing to play around with. Non-compliance with securities laws can not only lead to fines, but also imprisonment. You may need to register your stocks within your state or with the Securities Exchange Commission. In some cases, you may need to register your stocks either within your state and or federally with the Securities Exchange Commission. For this reason, I definitely recommend hiring a lawyer to ensure that your corporation and your stocks are properly set up. Well, that's all I have for this video. I hope this video helps to provide a basic understanding of corporate stocks. Of course, I look for your feedback in the comments. Don't forget to like, subscribe, and share with a friend. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. Bye.